Hello, everyone. We're back, and this is your favorite immigration news wrap-up show, right? We're here bringing you the latest news stories about, well, it's our favorite topic, immigration. And today we're going to cover some important developments in the immigration world, and we plan on doing so every other week, unless, of course, something major drops, and then you can count on us to be talking about it, dissecting it, and answering your questions. And here with my esteemed partner in crime, as they say, Martin Valko. Martin, how are you doing?
Doing well, doing well. How are you doing?
Great, thank you.
Drinking a little delicious cold brew that I've brewed myself.
Yeah. So that's the new from the new coffee machine that we have, right?
Right. Do you ever? What kind of
Yeah.
coffees do you make?
I don't do any cold brews. I my go-to is the donut coffee, which is it's pretty good. It's moderate. And then when we run out of those, I go to the Pikes Peak, which is a darker.
That's my favorite, right?
It packs in a lot of caffeine, but that's what I need sometimes. Yeah, that's what we need.
I mean, these new machines that we got for both offices are just incredible. Just wide selections from Starbucks to Lavazza to Pikes Peak. I think the digital display and the little carousel, and you can. I mean, I just did the cold brew. It's just fantastic. So, Stav loves it.
Yeah,
Stav loves it.
It's good. It's good. We did have the old drip for the longest time, and we called it Old Drippy or whatever we called it. But it was like 15, Old Faithful, like 15 years, and you can still drink. You can still taste the coffee from 15 years ago, which is interesting. Just like one of those wine barrels, there's something that ages.
Can't beat that, man.
Yeah. So we're going to talk about immigration, but before we delve in, folks, don't forget to hit like and subscribe to us if you want to receive, these breakdowns of immigration news that Martin and I deliver. And also we want to hit that 1,000 mark of followers. So please help us with that and share our content wherever possible.
Joe, appear, Joe.
What do we got, Joe?
Joe, tell us how many subscribers do we have right now?
Well, we're currently at 807 on YouTube.
807?
Yes.
Wow, that's good.
So within past 2 weeks, we've just been having like a huge increase of people, not just showing up, but like engaging as well.
It's awesome.
So don't forget, if you have any immigration questions, now's the time to ask us.
Yeah.
Yep.
Joe looks at it, and he does his best job.
Joe. Joe's the man. He's
right. Yeah. So this is your opportunity to get the updated on the latest happenings in immigration, and your opportunity as well to ask about these topics, or you can even ask about your case, or just about really anything. Or sometimes if you want to consult with us in private, that's okay too. Sometimes we have people who that want a second opinion on their case, but they would rather keep things, private. Well, just look no further and check out our information below to schedule a consultation with Martin or I, or with one of our awesome immigration attorneys. We'll be more than happy to help with y'all. And so, Martin, we're going to start things off by talking about a new immigration ruling that was handed down by the highest court of the land, the Supreme Court, that issued this decision earlier this week in a 5-4 decision, and basically this ruling is somewhat scary. The decision was basically, the ruling was that there are some immigration decisions that USCIS or the immigration judge may make, denying a request for a benefit, right? And the court said in some of those cases, federal courts can't review it if there was a denial, even if there's a mistake, which is, scary. And here they were talking specifically about an adjustment of status application. The case here involved Mr. Patel, a national of India who was applying for adjustment of status. And while his application was pending, he tried to get a driver's license. Well, according to Mr. Patel, he checked off the wrong box that indicates that he was a U.S. citizen. And that's what I find interesting, is that he didn't need to do that. You didn't need to apparently to apply for a driver's license in Georgia, you don't necessarily need to be a U.S. citizen. You just have to show them, a work authorization or some other form of legal status, in which he did. He had a work permit. Well, USCIS, they denied his application for that reason, because under the law, if you falsely claim to be a U.S. citizen for any purpose or benefit under federal, state, including driver's license applications, or any law, you're what's considered inadmissible. That's how they call it. And you're basically ineligible for your green card. And so his case, from when USCIS denied it, the case was transferred over to the immigration judge, and there the case was denied again. The judge didn't find Mr. Patel credible. And so normally the next step would be then to appeal to a circuit court, a federal circuit court of appeals. So you have the district court and you have the circuit courts of appeals, and then you have the Supreme Court. But here, the appellate court said, nope, we cannot review this. I'm sorry, we can't review this, because under the law, there are certain decisions that they cannot review, which relate to what is referred to as, and this is a very common term under immigration law. In our immigration books, this is a very common term and concept that's widely used. Discretion, which is, at the end of all things, does the person deserve this benefit? And that's the officer's call. And so under immigration law, there are certain decisions involving discretion that are not reviewable, and that includes some fact finding, except for situations where you're challenging the law, legal question, or constitution. But there's a surprising dissent with Gorsuch. What did you think about that? What did you think about the case, Martin?
Just what you said. It's just going to be scary if there's going to be this limit on reviewability, and you just can't go and clean up the errors, because it happens. And we see cases often where people are claiming falsely U.S. citizenship or being U.S. citizens for employment purposes. But as you mentioned, it was not necessary for him, to apply for it. And so, that's going to be interesting to see how that's going to. There was some exception, right? That we discussed it before, and you mentioned that there's going to be some way to get around it.
I think and the surprising thing here was Gorsuch, right? He was appointed by Trump, and he wrote a dissent. And here is, in this dissent, he was saying, federal courts, they've always played this important role of checking the agencies. If they make an error or they did something wrong, the individual who's applying for these benefits should at least be able to have that reviewed by a federal court. And so, and not to get into the weeds, but Gorsuch, he said, this determination was not really a discretionary decision, because it involved a question about eligibility, which is the first step before an officer ultimately decides whether this person deserves a benefit or not. So before that officer makes that discretionary call, there needs to be a determination of if this person eligible, including whether or not this person falsely claimed to be a citizen. So that needed to be reviewed. And you know what this really means is that, USCIS or the immigration judge, if they make a wrong finding based on an error, then that's you're gonna have a hard time trying to get it reviewed by federal court. But just to be clear, if USCIS makes an error, you still have the immigration judge that could review that in most cases. And I'm not talking about all applications for immigration benefits. Here they're talking about adjustment of status. So there are some that the immigration judge could still make an independent finding if USCIS made a decision. But what it does is really puts a premium on making sure that your case is well prepared and well argued from the beginning, because there might not be a chance to get your case reviewed. Right. So if you have a case like this, if there's a question about your eligibility, talk to a lawyer and get that squared away before you file the application. Moving on to so we had that, and that was a negative moment of this week. But not all things are negative. Here, DHS made an awesome announcement, right?
Yeah, so we got another temporary protected status. This was announced back in March 15th, when the designation was announced for nationals of Afghanistan. So we've recently had Ukraine that we discussed, and a couple of other countries. But typically there's an announcement, and then there will be a publishing of the rule in the Federal Register. So it is estimated that there's about or over 72,000 Afghan nationals in the U.S., and so they'll be eligible to apply for the temporary protected status. They had the humanitarian parole available for Afghanis that were, fleeing after the withdrawal of the U.S. troops, and we have there's thousands of those pending, because there was just this huge run on the USCIS with these applications. So this will be a 18-month designation. You have to show physical presence from the date when it was announced and the country was designated, which was March 15th of 2022. It was going to run for 18 months through November 20th of 2023. And you can file both applications online. So you have the TPS application, the form I-821, you can file it online. And then with that, you can apply for an employment authorization document, work permit, also online. So the process begins today, registration May 20th. So if you are Afghani national, and sometimes you may have somebody in a non-immigrant status that does not authorize employment, foreign students, for example. And so this might be of benefit where they also apply for the TPS, and once they have the employment authorization document, they can continue going to school, but at the same time, they are eligible to be legally employed. So that was a great. It was announced, but now we have the registration that formally began today.
Yeah, definitely a step in the right direction, and it complements what they're trying to do with this parole, right? Which has, as far as our experiences have been with this program, it hasn't been quite positive, but having at least TPS is a step in the right direction. And they do have to show the physical presence. I think you mentioned that on March 15th, right?
Yeah.
Okay, yeah, and other requirements. But that's great. Moving on, we talked about, and we've been talking about news regarding politics. It's always gravitating toward politics, and there was a news article by Roll Call that documented this latest push to try to get legislation passed for Dreamers. It's not too late, right? You think? What do you think?
Well, which one are you talking about? Are you talking about the documented Dreamers?
So about the Dreamers, right? So Senator Alex Padilla, he was in a conference and he was presenting a bill to benefit, I think, roughly 250,000 immigrants who grew up here, i.e. the Dreamers, people who have DACA.
Yeah. So, this is really, so when you look at this article, and this is what's kind of interesting about that, it has co-sponsors both in the House and in the Senate. So in the House, it has, I think, 10 Republican co-sponsors. In the Senate, you have Rand Paul, who often kind of rails against new bills. And so you have 3 Republican co-sponsors here as well. This really, it talks about documented Dreamers. And so, who are these people? And so these are folks that grew up here, that were brought in. And when I say folks, these are kids that were brought in by their parents. So for example, parents came in on non-immigrant visas. They could have an H-1B, for example, and the dependents and kids here specifically would have an H-4 status. You would have dependents to treaty investors or traders, E2s, L1 intracompany transferees. So you'll have dependents, L2s, F1s and F2s, right? So they are basically here lawfully. They can go to school, all these fun things. So that's why they call them documented Dreamers, right? But at 21, when they reach the age of 21, they age out. And what that means is all of a sudden they find themselves out of status, and there's nothing that they can do except trying to kind of go on their own route, right? So either change status from E2 dependent to an F1. And so here, basically, they're saying, let's legalize these people. Let's let them, at the very least, let's not make them undocumented. And so that's something that is going to be debated, and we'll see if it's gonna get through. There were a couple of other things that were mentioned. They were bringing up also bipartisan guest worker program that's going to include H-2A, the agricultural workers, and H-2Bs, any other seasonal workers. So there's movement in the Congress, which is very positive, and but that's basically what it addressed, the documented dreamers. When I first saw it, I'm like, great, we're talking about dreamers, and but these guys are dreamers,
right,
as well. And we deal with this as well, dependents with H-1Bs, and we get these questions from parents like, well, what do we do? What can they do? And so they often have to self-deport, right? They've been here for, I don't know, some from India or China, could have been here, brought in when they were 2 or 3, and all of a sudden 10 years later, the parents are still waiting for the application for a green card because of the backlogs in their preference categories. And all of a sudden, they're 21, and if they don't continue, if they don't go to school, if they don't get sponsored individually and independently of the parents, then get on a plane and go to the country that you really don't know. You just visited, but there's nothing there for you because your family's here. So, that would be fantastic if this would go through. That'd be really good.
Yeah, I think it's fantastic that, there's some signs of bipartisanship, and you mentioned even Rand Paul is on board, and they're looking for areas of agreement, and hopefully that will just gain some more momentum. But you see this other issue, right? The border security and what went on with the Title 42. It's being used around as maybe a bargaining chip. So we'll see what happens. It's certainly something that we're going to be tracking and sharing that information and our insight with you as this news develops. Folks, we're almost we're over the halfway mark in terms of the news items. So if you have a question, feel free to drop it. We'll be happy to address those. Moving on, Martin, there was a report by Axios, which they talked about along those same lines, right? Is this push for keeping and attracting people who will serve the interest of the United States, right?
So analysis of these highly technical fields shown that half of the people in it are foreign born. And I think historically, the U.S. have done a pretty bad job in retaining that talent. And so there's nobody can be surprised about the competition between the U.S. and China. And last year, both House and the Senate passed a bill and to pour money into what's called the National Science Foundation and other federal research agencies, and that's just basically in the push to stay competitive with China, because it seems like on some fronts it's been eating our lunch. But where does it begin? It begins with the talent, right? And it's as I said earlier, you have foreigners coming in. And the disadvantage really because of this per country quotas per preference category. So if you're applying for a green card, you are kind of put in the different preferences depending on the minimum qualifications for the job. So some may require bachelor's degrees, some may require advanced degrees. And so those that require at minimum a bachelor's degree with less than 5 years of progressive experience, they're in the third preference category, the EB3. And so when you are from a country like India and you want to apply for a green card, your wait time right now, I just checked the June bulletin, is 10 years. 10 plus 2 months. From China, it's 4 years. And so, countries like Canada and the UK, Australia, even, they do a better job in recruiting and retaining talent. And so the US, they really got to get on top of this. And this proposal is the Competes Act. Basically, they want to exempt the cap. So you are not subject to cap where you have to wait those 10 years or 4 years if you're from China, but it's for students. So if you have a doctoral degree in STEM, so in STEM fields, so sciences, technology, engineering, and mathematics, STEM, short for STEM, that's basically, if you have doctoral degrees in these fields, then you should not have to wait, for that, that long. So your typical route would be, being an F1, having an OPT, which is a work permit. And then if you graduated with STEM degree, then you get additional 2 years. During the time you're seeking, feverishly an employer who's going to be sponsor you. So hopefully the one that you're working for, the employer would sponsor you for an H-1B. And so again, we know H-1B is highly demanded. It was close to 500,000 applications this year for registrations for 65,000 plus 20,000 with those that have advanced degrees in the US. And so, the chances of being selected in this lottery are pretty slim. So that's why those that have STEM degrees, they have the additional 2 years. So at least they have 3 years to kind of go through the lottery and play it. Then they get it. And then if they're from one, country like India or China, then, oh yeah, you got to wait another 10 years, and that just depends. It's not just from the time you have to go through the sponsorship process, which begins with labor certification in these preference categories. And so, if everything's successful, you get to the petition, which is a step 2, which will probably be in about 8 to 14 months. And at that point, you're looking at another probably 8 years before you can apply for a green card, before you can just really put down the roots, which, imagine that, right? I mean, I was at a tournament for my son the other day, and I spoke to a gentleman that I've known for a while who's from India. He said, I've been in this process for 17 years. And, the kid's only 11, so, kids can't sponsor him, but he said, I had 4 I-140s approved. And 17 years in this predicament. And so that's what we're doing to a lot of these foreign students. So again, Competes Act would be an exemption on these caps, so they don't have to wait that long for these green cards. And it's for people that have degrees, the students and graduates with doctoral degrees in STEM. And it doesn't matter where you obtain that degree, whether it was from the U.S. institution or foreign institution. So there were some concerns by some lawmakers about potentially some potential theft of intellectual property and kind of limiting foreigners' access to research, and so that's going to have to get worked out. But again, this is a bipartisan bill that is proposed, and hopefully that's going to go through as well, and that's going to be the first step in our competition with other countries such as China, and hopefully we'll get to retain the talent, because a lot of times we bleed it. We educate the talent, and guess what? They go back to China. They go back, to their home country or somewhere else, and all of a sudden we just gave them all this knowledge, and they're going to end up somewhere else.
Yeah, and that bill again is called the America Competes Act, which basically calls for cap exemption for those with the STEM degrees. Moving on to our last news item, there is an article by Border Report which indicates that this new battleground that Abbott, we know that he's politicized this whole immigration issue. We saw that with the busing of individuals, the using your state troopers on the border and all that. But now he has his sights set at schools. His Border Report indicates that there's the titles: "School may be Texas' next immigration fight." And so, this is one way that he's testing his, hardline immigration measures for his political career. And he's trying to chip away and say, individuals. And to give you a little bit background, I mean, there was a Supreme Court case, it's precedents that says that the Supreme Court decision, Plyler versus Doe, which says
settled law.
Right, settled law, right? Right to public education extends to all children, undocumented children, and that's 40 years of settled law. But we've heard that phrase already, settled law, right? With Roe versus Wade. What's going on here? What's your take?
I don't know. I mean, you know, you mentioned the Patel's case earlier on. Do you know what were the five? I mean, if Gorsuch was on the dissent, then I mean, was it strictly kind of a right-leaning judges? Well, there's got to be at least one left-leaning, wasn't there?
Well, there could be. I mean, the Gorsuch is a person who reads the law and is pretty what you call a straight reader or a strict constructionist. He just reads the law and doesn't put any interpretations into it. Whatever the law says, whatever the text of the law says, that's what it is. And so there are some issues that he will side with what you would call your liberal wing and others in conservative. So it's kind of hard to determine that. But this is settled law. And whether you're a strict constructionist or not, whether you're conservative or liberal judge, you know, settled law is settled law. But there is this attack on settled precedent cases, and this is what Abbott is trying to test.
So look, we've got 6 months to elections, right? To the midterms and to the gubernatorial elections, and to me, it's pretty political. I mean, this has been settled, and it is just kind of getting the waters, you know, kind of what's the expression? Just getting some movements there, and so we can get some traction. He can get the social media buzz, and it's all. I think it's, you know, it's just kind of grandstanding at this point. Everybody knows it's a settled law, but like you mentioned, Roe is also settled law, and it may not be any longer or for much longer. So we'll see. I don't know. Will this make it all the way up if he's going to challenge this?
Oh, most certainly, because it's but we'll see what happens. We'll see how that is presented. Hopefully it'll just
it's election year, folks. So you know, take it for
crazy
that.
Stuff.
I would say
crazy stuff. Well, we got a question. So moving on to the questions that we have. Let's see here. Let me see if I have it. So I think I do have it here. Do we have it? Let me show it.
I think I just saw some.
Is it showed? Is it showing? I'm sorry.
Joe? Yeah, I see. Hi, I have a DACA. Yeah.
Okay. All right. So here we go. So yeah, JC, thank you, JC, for your question. JC has DACA, and his dad got 245I from his uncle back in January 2001. JC was 7 at the time. Does that benefit me in any way? Can I adjust status without marrying a U.S. citizen? What do you think, Martin?
I think we're going to need some more information, but so, you know, who's the petitioner? Did the uncle had sponsor JC's father?
So I think he's trying to do it through, yes, the uncle as a dependent petition, as a dependent beneficiary, I should say. The petitioner appears to be the uncle. He filed this petition. Father was the what they call a primary beneficiary. He was included in that petition. You don't have to be named in that petition. You just have to be under 21 as a minor and single. And he was 7 years old. He doesn't want to do it any other way. Can he do it through this petition? And I think this is a petition. The uncle, I'm assuming, was a U.S. citizen, because that's the only way they could file for siblings. And so this would fall under the fourth preference category.
Fourth preference, right?
And now
we need to know what country they're from, right? So I would assume that if it's Mexico, then I'm just looking at the dates for filing family sponsored visa applications, which currently Mexico fourth preference is showing March 1st of 2001. So if this was January 2001, there are a couple of other things that have to happen where the father would have had to have been present in the U.S. on December 20th, 2000. So we have to show physical presence. And then father would have to be adjusting. So JC would be able to adjust. JC would have to look at his age to see if he did not age out over the age of 21. And so if JC, if you are older than 21, then we'll have to see how long that petition was pending. And at the time when you'll be eligible, if you already should be eligible, then we'll have to see that time that the petition was pending. That could be deducted from your current biological age. And if you are still under the age of 21, then you should be able to get your adjustment. But again, there's a couple of unclear facts that we need to find out. Ideally, there's a link in our comments where you can schedule a consultation. So, we will do it in confidence and do it privately, and then we can look at all of the options. But those are a couple of questions that we would need to be able to answer your question. But thank you for that, JC.
Thank you, JC. Just as Martin said, we'd have to make a determination, and it's best to schedule consultations where we could get all your information, do that calculation under the Child Status Protection Act. Well, folks, that's a wrap. I hope you liked our information. And speaking of
real quick, before you say that, anything new on Title 42 that is supposed to go be lifted in Monday?
I haven't heard anything major. Have you?
Well, so I was just looking through the items because there's a judge in Louisiana, a federal district judge, that was supposed to decide on the preliminary injunctions by Missouri, Louisiana, and Arizona, 3 Republican-led states. There was an injunction to stop the end of Title 42. And I think as far as 3 or 4 days ago, the Biden administration was asking as well the judge to make a decision before Monday, before May 23rd. So that's what I was asking. Hey, it's Friday. Have we heard anything? Because
that's how immigration goes sometimes.
Yeah, if nothing happens, then on Monday officially the Title 42 it gets lifted, and it will not be used as a tool to keep immigrants, asylum seekers out of the country, out of the U.S. That wasn't really its intent. So we'll see. But as of Monday, Title 42 should be no longer enforced at the border.
Well, we'll bring that information to you once more information becomes available, and as you mentioned, once that there's an official finding or official decision from the court, and then the response from the administration, how they're going to apply it.
Yeah,
we'll let you guys know. Don't forget to like and subscribe to our show to get the latest news and information. If you want us to cover a particular topic, please send us a message. We'd love to hear your feedback. And do you know how else you can get the latest news about immigration? It's through our app, Law Pilot Guardian, an app that my law partner Martin and I developed for you guys. Through this app, you will be able to receive notifications about news. But not only that, what else, Martin? Take it from here.
No, it's fantastic. And I just want to say, who is better prepared than our clients or prospective clients that have this app installed on their phones? And it's like you mentioned, just breaking news notifications. You get it to your phone. You don't have to check your email. It's going to come through your screen as a push notification. With us, if you're registered to us, you will be connected to us. And when I say connected, it means that there's that red button on the screen when you press it. If you have an emergency, we'll get notified. We can see through GPS where you are. And we can actually listen into audio, which gets recorded and uploaded to the cloud. So this is something Nick and I co-founded, and it's just been a fantastic tool for our clients. And also, if you ever wonder about what rights do you have when you're speaking to law enforcement, when you want to know a specific question, it's all there. It's really easy. Just scan that QR code and register, and then download it, and you'll be connected to us. So it's just a great way of staying and keeping in touch with us.
Well, guys, that's it. Thank you guys for joining us. Thank you, Martin. Thank you, Joe, as always. And we'll see you guys next time.
All right. Take care. Have a good weekend.